There was an interesting opinion published by the appeals court last week. A woman crashed her car. The police arrived. They noticed the odor of alcohol on her breath, but she had blood around her mouth and she had some blood on her shirt. Now, the police asked her if she needed medical attention, and she said she didn't. Regardless of that, they called an EMT, and the EMT brought the woman to the hospital, where the hospital drew blood from the woman. The police later charged the woman with an OUI, and in order to establish that there was alcohol in her blood system or in her bloodstream, they summoned the blood sample, or the results of the sample, from the hospital. Now, this woman challenged, for a number of reasons, challenged the use of the blood sample. And one of the arguments that she made was that it was a violation of her Fourth Amendment right against unlawful search and seizure. The court said that it is not a state action when the hospital takes a blood sample from you, and therefore the Fourth Amendment doesn't apply. So keep this in mind, because this is a frequent tactic used by prosecutors. If there is a crash, regardless of whether police suspect that the driver was drinking or not, if they think that that person needs medical attention, that person goes to the hospital. Right? He or she doesn't get put through a field sobriety test or breathalyzed. They go to the hospital, and then the prosecutor will seek to get the hospital records to establish that there was alcohol in the person's blood system at the time of the crash. So keep this in mind, and just almost expect that if you go to the hospital after a crash, and if there's alcohol in your system, if the hospital takes your blood, the Commonwealth is going to get a hold of that sample and can very likely use it in criminal proceedings against you.